This is Eye on Bankruptcy, brought to you by the American Bankruptcy Institute. Here is Professor Juliette Morangello of Widener University Commonwealth Law School.
Hello, and welcome to another edition of Eye on Bankruptcy. I'm Juliette Morangello, the Commonwealth Professor of Business Law and Director of the Business Advising Program at Widener University Commonwealth Law School in Harrisburg, Pennsylvania. And this month, I'm your host. Eye on Bankruptcy is a monthly show of current legal developments produced by the American Bankruptcy Institute. We come to you from ABI's studio in Alexandria, Virginia, just outside Washington. Our website, eyeonbankruptcy.com, contains an archive of more than 4 dozen programs featuring leading practitioners, judges, and scholars. The show qualifies for an hour of CLE credit in states where it is pre-approved. Today, we'll focus on bankruptcy and appellate court opinions from the past month. Included are several of note for both commercial and consumer practitioners. This month's docket, from the pages of Rochelle's Daily Wire, features a new take on sovereign immunity, as well as another opinion that seems to cast doubt on lien stripping via Chapter 20, and the meaning of unfair discrimination in proposed Chapter 11 plans. We will consider varying circuit approaches to the enforcement of covenants not to compete. We also have 2 other Chapter 13 cases, a tax foreclosure opinion, and a case under the federal PACA law, up to 9 opinions in all. We are honored to have with us 2 guests well qualified to discuss these cases. Judge Thomas Catliotta was appointed to the Bankruptcy Court in the District of Maryland in 2006, sitting in the busy Greenbelt Court. Prior to his appointment, Judge Catliotta was a partner at Pillsbury Winthrop Shaw Pittman and its Washington, D.C. predecessor, Shaw Pittman. There, he chaired the Bankruptcy and Insolvency Group for 7 years. His practice addressed all aspects of insolvency law, including the representation of debtors, creditors, and committees in bankruptcy courts across the country. Judge Catliotta also serves as the chair of the Bankruptcy Judges Advisory Group, which advises the Administrative Office of the U.S. Courts on matters of the bankruptcy court system. A regular speaker at bankruptcy seminars, Judge Catliotta is a graduate of Marquette University and the Columbus School of Law of the Catholic University of America, where he received the Faculty Award. He also holds a Master of Laws in Taxation from the Georgetown University Law Center. Elizabeth Sieg is a partner in the Richmond, Virginia office of McGuire Woods. Beth's practice focuses on restructuring and insolvency and commercial litigation, including corporate bankruptcy proceedings and other creditors' rights issues. She's been involved in major cases in the retail, manufacturing, energy, and technology spaces on behalf of debtors, creditors, officers, and directors, among other stakeholders. Beth has also been named to every list of legal rising stars you can make over the past several years. After earning her law degree with honors at the University of Richmond, she served as law clerk to the Honorable Kevin R. Hennekins, bankruptcy judge for the Eastern District of Virginia. Beth's undergraduate degree is from Georgia Tech, magna cum laude. Thank you both for joining me, and welcome to Eye on Bankruptcy.
Thank you.
Well, thank you. Our first opinion today is from the Bankruptcy Court for the District of Delaware, and it provides a terrific primer on the role of sovereign immunity in bankruptcy cases. The debtor in Re La Paloma Generating Company owned and operated an electric generating facility in California. The debtor had paid all property taxes assessed to the facility and thereafter sought a refund of the amounts paid. The debtor claimed that the property values used by the California State Board of Equalization and the county in which the facility was located resulted in the debtor paying about $14 million in excess property taxes. The debtor brought a motion under Section 505 of the Bankruptcy Code requesting that the court determine the value of the facility and the debtor's entitlement to related tax refunds, which the opinion calls the tax dispute. The State Board of Equalization filed a motion for summary judgment arguing that the bankruptcy court does not have subject matter jurisdiction to hear the tax dispute pursuant to Section 505, and that the court has no jurisdiction to decide the tax dispute on sovereign immunity grounds. So first the court addressed the 505 issue, because if that had taken care of the case, the court did not have to go to sovereign immunity. And 505 permits the bankruptcy court to determine the legality of any tax, whether or not paid. However, the court may not determine the right of the estate to a tax refund before 120 days after the trustee properly requested the refund from the relevant governmental unit. Because the debtor had requested only $3.5 million from the State Board of Equalization, the court held that it had 505 jurisdiction only over that amount. Do you agree with the court's interpretation of 505?
Well, first of all, let me say I agree with you. That's a terrific primer on sovereign immunity. I mean, when you sign up and agree to do something like this, and you're presented with a 66-page opinion, you sort of go, oh boy. But this opinion, and I know we don't make qualitative assessments here, but this opinion is so logical. It's laid out so wonderfully, and it covers so much ground. It really is a fantastic opinion. Yeah, I think as you say, Judge Sanchi had to first decide whether or not there's to use my term, stated a claim under 505, and he did. He said that the first challenge was that Section 505 says the action must be taken within the time by the trustee, and the state agency said it was pre-petitioned by the debtor, and therefore it's not the trustee. And he said he had no trouble with that. He said under Section 1101, the debtor and the debtor in possession are the same thing. Under Section 1107, the debtor in possession stands in the shoes of the trustee. Therefore, the action taken by the debtor pre-petition was sufficient for Section 505. He then looked at two state law, challenges. One of whether or not there's an exhaustion of administrative remedies, and whether or not the appropriate amount was sought. And he determined that under state law, there was a claim for $3.5 million. And therefore he could assert jurisdiction under Section 505, and therefore he had to look at sovereign immunity.
Beth?
The thing that struck me about this opinion is, getting through the portion where the court ruled that the debtor could properly request, it didn't have to be a Chapter 11 trustee. Mm-hmm. Just when we thought it was going to be a case where the IRS, the government, did not win, then we switched into the analysis of, what the effect was on the value the debtor had put on the property when they were claiming the refund in state court. And so I thought the portion of the opinion where the court was examining how and why that amount should be capped based on the statements that had been made in the original filing, I thought that was a really interesting piece of the opinion where the de novo standard of review came up, because the decision was it has to be capped at, is it 3.5 million?
3.5, yeah.
Because he doesn't need to look beyond what was put in those filings, and I thought that was a really interesting development in the decision. And it was an area of state tax law that I had not previously ever seen, so I thought that was an interesting piece of it, and one that maybe he didn't necessarily need to reach given the outcome of the rest of the case.
Well, I was going to say, I think we should point out that the reason why he had addressed that was Section 505 sets this time limitation and requires the debtor to have properly requested the claim. And so he had to consider whether it was properly requested. And that's why he got into the state law issues about whether or not the debtor had properly complied with the state law procedure, and whether the debtor therefore was limited by state law under what it could seek in his court.
Yes, absolutely. So there you're limited to the 3.5 million, so that doesn't dispose of the whole tax dispute. So then the court turns to sovereign immunity. And again, I agree with you, Judge, on the logic of this opinion, because it really walks very well through all of these issues. So next the court turned to sovereign immunity, and the debtor had argued that the State Board of Equalization waived its sovereign immunity by its conduct during the bankruptcy court litigation. the court disagreed, which of course leads to a discussion of what kinds of litigation actions by a state entity waive that entity's sovereign immunity, and why was that not the case here?
Well, the outcome really was, it depends on if the immunity at issue is immunity from suit or immunity from liability. And it seems like under the case law, really, it's almost impossible to waive, for a state to waive its right to immunity from suit. That, you know, some of the cases involved an assertion of immunity from suit after a full-blown trial and appeal on the merits. So in the type of immunity that was at issue in this case, it seems almost impossible to waive that through litigation conduct. And then the conduct here was certainly not as extreme as that. It was a stipulation that really set a briefing schedule on the debtor's determination motion. So it really wasn't even the kind of thing where you get through the full-blown trial on the determination motion and then have it asserted. The state had been asserting it from the beginning.
Right.
He drew a distinction between a voluntary party and an involuntary party.
Yes.
And where a state obviously goes into court, that's a different issue. But where a state is a defendant, it's involuntary. And in that situation, it's very difficult, as Beth said, to waive sovereign immunity. You don't waive sovereign immunity, he said, just by participating in the proceeding and defending on the merits. And in fact, there was a Third Circuit case that he cited that said you could raise sovereign immunity if you're an involuntary party on appeal for the first time. Mm-hmm. So the defending the merits, you need more than that. And he talked about some other areas where you might be able to find waiver would be if you'd filed proof of claim and then you were named in a party, or if you removed the action to bankruptcy court, or if you injected yourself into the action as a third party. Those might be enough to constitute the waiver, but simply defending the claim is almost, as Beth says, very, very difficult standard to waive sovereign immunity.
Right, and that's the point that the court made. So then the debtor's last argument on sovereign immunity was that the proceeding at issue was the type of proceeding that states consent to by their ratification of the bankruptcy clause. In disagreeing, the court surveyed the landscape of the Supreme Court's holdings in various sovereign immunity cases, including Seminole Tribe, Hood, and Katz. Why does this action not fall within the consent by ratification waiver?
Well, the consent by ratification waiver argument, which is really stems from Hood and Katz, after sort of the Third Circuit has interpreted Seminole as saying Section 106 is unconstitutional. And so you look to what Katz said was, look, when the states ratified the bankruptcy clause, that not only gave Congress the authority to act in the bankruptcy area, but it essentially limited or subordinated the state's sovereign immunity rights in the context of the bankruptcy area in some respects. And so the standard that Katz came up with, that Judge Sansi focused on, was there really has to do with the sort of the core jurisdiction of the bankruptcy code, looking at, is this an in rem claim? So in Hood, it was dischargeability of a student loan debt. That court said it's in rem. In Katz, it was pursuing a preference, and that court said, you know, this was a preference action was part of the bankruptcy function far back as the 18th century. So clearly it wasn't. It clearly was included, and so the court sort of set forth this framework that you look at. The sort of the core bankruptcy function is jurisdiction over property, jurisdiction over distribution to creditors, and discharge. And if it focuses on those three areas, one of those three areas, then you have an argument. Then you start getting into the case where it's consent, it's a waiver by consent to ratification.
Right.
Mm-hmm. And the court really focused on, you know, when you're looking at the individual claims that the court has to analyze, it will look at whether the law at issue, he had to look at Section 505 here, whether that law is part of the, you know, congressional direction to treat creditors and parties, state and private actors in bankruptcy cases uniformly. Mm-hmm. So the uniformity concept came into play, and then the core was it historically part of the core process of administering the estate?
Yes.
And the analysis, I thought, of whether 505 is directed to uniformity was a bit surprising to me, because it seems at first glance like, oh, well, this is a very particularized statute that deals with tax assessments. That seems like it is geared to governmental entities and not all creditors. And then, so, when Judge Sanchi then explained what is meant by uniform in a more robust sense, and explained that, this is not just a section that governmental creditors can take advantage of, it's debtors can take advantage of it and all of that. I thought that was very illuminating, and probably is going to give a lot of guidance in future cases where courts have to look at different statutes under the bankruptcy code to see, is this really headed in the direction of a uniformity of treatment kind of analysis?
Yeah, the debtor argued and said, well, look, our electric utility plant's at stake here, and so that's property. It's property of the estate, and therefore you have jurisdiction. It's in rem jurisdiction, and the judge said, no, wait a minute. All that's at stake here is the value. There's no issue about who owns it, who has an interest in it, whether there's liens. Then the debtor said, well, we're trying to get a refund. A refund is, there's a trust, there's a race, there's property, that's property of the estate. And he said, no, that's not sufficient to get to that level of what Katz was looking at, because there is no fund, there's no race. There's just a refund that was paid, money was paid pre-petition. So that's not enough to get to the Katz level of in rem jurisdiction, or to the this core function. Now he did say, interestingly, that look, if this had been paid post-petition, and so this was the estate paying funds that the estate was trying to get back, that might be a different story.
Yes.
Because then you're talking about property of the estate, you're talking about a set, a finite group of funds either way, and so it might be a different issue.
Yeah.
Yeah.
It was a great opinion for those of watching who are interested in the sovereign immunity issues. This is a really good one to look at, and thank you so much for your analysis of it. Really a great case. So next we go to consumer bankruptcy, and we go to the controversial to some practice of Chapter 20. This next opinion in Ray Washington is from the Bankruptcy Court for the Central District of California, and it calls into question the use of Chapter 20. The debtor in this case had received a Chapter 7 discharge in 2012. She filed a Chapter 13 5 years later. In the Chapter 13, she sought to avoid a completely underwater second mortgage on her home. That lien predated her Chapter 7, so when the mortgage creditor filed a claim in the Chapter 13, the debtor objected on the basis that her personal liability on that claim was discharged in the Chapter 7. The court analyzed sections 506 and 1322 of the Bankruptcy Code to conclude that the creditor's claim was, after the lien was avoided, converted into an unsecured claim against the estate and would have to be paid as such. The court concluded by saying there is no mechanism under the Bankruptcy Code that would allow a debtor to avoid a lien and discharge the in personam liability without the obligation to make a good faith effort to make payment on that claim. And the court was very adamant here that there's no other way to read Chapter 13 and Section 506. So, do Sections 506 and 1322 lead to the inescapable conclusion that a debtor cannot use a Chapter 7 followed by a Chapter 13 to escape liability on a wholly underwater second mortgage?
Well, it's a really interesting opinion, and very sort of tight in its logic, looking at those two statutory provisions. It says, look, as we all know, really, Chapter 20 and stripping off liens is a two-step process. First, you look at Section 506, and you determine what's the value of the secured claim, what's the value of the unsecured claim, and then the authority for stripping in a Chapter 13 is 1322B. So you apply that. You look at 506A. There is no value in the collateral, so there's no secured claim. There is we'll get to whether or not there's value in the unsecured claim, but if you then look at 1322b2, 1322b2 says you could modify the rights of a holder of a secured claim. There's no secured claim here. Or you could modify the rights of a holder of an unsecured claim. There is no unsecured claim here.
Right.
So that means that there must be an unsecured claim because courts do allow Chapter 20s to strip. And the source of the unsecured claim is the language in 506A that says to the extent the allowed claim exceeds the value of the collateral, it's an unsecured claim. And that sort of creates, and the judge puts creates in quotes, but that creates the unsecured claim.
Yes.
And therefore, it sort of revives the discharge claim, and therefore there is a unsecured claim under the plan that has to be treated under the plan. So it's very interesting assessment of 506 and 1322.
Yeah. What is your read on it, Beth?
I honestly thought this was maybe one of the most fascinating opinions that we're talking about today, because I mean it really seems pretty obvious that if we're going to talk about for purposes of Chapter 20, if we're going to use this fiction that there's an unsecured claim that's created by the 506 analysis, then what's the basis to disallow that claim at zero? You have to have an unsecured claim for 1322 to even apply, and there's no basis, it's not a state law unsecured claim, it's a 506 unsecured claim, and there's no basis to disallow it. And it all came together at, I think, near the end of the opinion when the court pointed out, in what kind of cases does this really matter? This matters in Chapter 13 cases where the debtor has excess income that they are not devoting to pay to their unsecured creditors. Mm-hmm. And so it makes a difference to the junior creditor in that circumstance and that one alone. And so I think my takeaway from it is I don't think the court was suggesting that Chapter 20 is not available. Chapter 20 is available, but if you have excess income, you can't disallow this unsecured claim that the code has created for the purpose of you doing a Chapter 20. So
I would say the logic of the opinion to me supports more the notion that you can't have a strip in a Chapter 20 because
Yes.
there's no unsecured claim. Then supporting the notion that you can have a strip, but there is an unsecured claim because the source of the creation of the unsecured claim, 506A. I haven't looked at every case, but I haven't seen a case before where it converts a non-recourse loan to a recourse loan because of the language of 506A.
Right.
We know in Chapter 11 it's not necessary because of 1111B.
Yes.
So it's that next step, it's that final step where he says the sort of source of what creates that unsecured claim is the language in 506A. That's what I find interesting. I do agree with Beth. Very interesting opinion, and it'd be fascinating to see where this goes.
Yeah, it will be fascinating to see where this goes because I know there has been a lot of chatter about this opinion because it seems to really remove Chapter 20 from the table, right?
Well, if you accept that it does create, there's somewhere somehow there is this unsecured claim, it makes Chapter 20 more expensive in some cases. But I don't think it eliminates Chapter 20 unless you don't accept the notion that the unsecured claim was created. If you accept the notion that there's an unsecured claim, then you just have to deal with it under the plan. It may make it more expensive, but so I don't necessarily think it's a death knell for Chapter 20, but I do think it's the first opinion that I've seen that addresses the issue in the context of drilling into 506A and 1322B in the context of a Chapter 20, and I thought it was something that we'll all follow, I'm sure, with great curiosity.
Yeah, I'm sure. Well, thank you for your analysis of that opinion. So the next opinion is from the U.S. District Court, from the District of Delaware, and it comes from the Tribune Media bankruptcy. Tribune filed for Chapter 11 1 year after it had completed a leveraged buyout. The appellants in this opinion, Law Debenture Trust Company of New York and Deutsche Bank Trust Company Americas versus Tribune Media Company, represent the interests of certain pre-LBO debt, the Class 1E senior note holders in the confirmed plan. Two other series of Tribune notes were were contractually subordinate to these senior notes. According to the subordination agreements in a Tribune bankruptcy, any recovery by these two other series would be payable to the Class 1E creditors, the senior note holders. The plan provided that any recovery from those other series were to be distributed pro rata between Class 1E and Class 1F, which was a class with 700 primarily individual and small business creditors. The difference between the trustees' recovery under the plan and their desired recovery if the subordination agreements had been enforced was 2.9% by recovery percentage. The trustees, the appellants, challenged the bankruptcy court's determination that the subordination agreements did not have to be enforced, and they also challenged the bankruptcy court's determination that the plan did not discriminate unfairly against the senior note holders. The district court affirmed both of the bankruptcy court's holdings. So here, although the parties in this case, it appears, had agreed to use the Markel test for determining unfair discrimination in a Chapter 11 plan, other courts use a four-factor test that has been around for a while. So I'm curious as to what the both of you think are the relative merits of the Markel test and the traditional four-factor test.
Well, the Markel test has a lot of advantage in that it tries to sort of embody a lot of the various disparate elements that go into whether a creditor is being unfairly treated. Looking at what the risk allocation was for these creditors outside of bankruptcy, taking into account sort of a more organic view of things. But the way it was boiled down in this case was pretty simple. You apply a presumption of unfair discrimination, but only if it results in a materially lower percentage of recovery for the dissenting class. And the relative merits of all these tests, I think, is, I guess it's, as a threshold matter, debatable. Are they really all that different?
Good point.
As they really are kind of driving to the same series of facts that the court is going to look at about the nature of the claims. The very interesting thing here is that the focus is on materially lower percentage recovery. Well, in the non-bankruptcy world, $30 million is a lot of money, even when you have a $1 billion claim or whatever it is. So I thought the way this could have been enhanced a little bit is look at percentage of recovery in the larger sense of what is at issue. Because if it's a 7% increase in distribution on a $20 distribution, that's probably not material. But when the 7% difference is $30 million, that sure seems material. So I think, the Markel test has a lot of advantage in trying to capture that whole world, but seem to miss ultimately the real world impact of $30 million is quite a lot of money.
I certainly appreciate the materiality element of the Markel test. I mean, the statute is unfair discrimination. You can discriminate, you just can't do it unfairly. So if it's not a material discrimination, then why are we even fighting over it? So I do like that element of it. I'm not daunted at all by bankruptcy judges determine materiality all the time. What's reasonable, what's material. And here we have both a bankruptcy judge and a district court judge saying 2.9% is not material, and we'll see where this goes. But the sort of the materiality element, I think as this test works its way through the system more and we get more case law, we'll start getting parameters, perhaps start getting standards, more discussion, and we'll see where we end up. But I do like the injecting materiality into the process.
Okay. All right. Let's move on to our next opinion. Our next opinion is Cybertron International versus CAPS from the Bankruptcy Court for the District of Kansas. And this opinion involves a covenant not to compete. Here, the debtor, Michael Capps, had sold his interest in his company to Cybertron International in 2015. Cybertron hired him at that time, and he signed agreements in which he promised not to compete with Cybertron for 5 years, not to disclose any of Cybertron's proprietary information, and not to solicit any of Cybertron's customers. After he filed for bankruptcy in 2016, Cybertron fired him and then sued him in a state court a year later for violating these agreements. Mr. Capps argued that his obligations under the agreements gave rise to claims that were discharged in his bankruptcy case, and that Cybertron's lawsuit violated the discharge injunction of Section 524 of the Bankruptcy Code. He also argued that the agreements were executory contracts that had been rejected in his case. The court disagreed on all counts. So let's start with the issue on which courts seem to have a difference of opinion here, and that's as to whether a covenant not to compete gives rise to a claim. Did the court here take the right approach?
I think so. Well, first, the court here had Sixth Circuit precedent
Yes.
that he was relying on, and so the question is, was the Sixth Circuit correct? But
Good point.
but I mean, the bankruptcy code is Section 1015 says the language a claim is a right to equitable relief for breach that includes a right to payment, and so a covenant not to compete without a corresponding ability to sue for damages would not be a claim.
Right.
And I think that was the result, and that was the result of the precedent. And he even cited the Seventh Circuit opinion in Udell that said that even if there's merely a liquidated damages provision, that's not really a claim for damages relief. So it does not constitute a claim, and therefore it's not discharged in the case.
Beth?
My takeaway from this case was really a question. If you are the debtor that's in this circumstance, and the consequence of, even if you assume it was deemed rejected, that's not termination. The contract doesn't cease to exist.
Yeah.
So if you are the debtor who has a covenant not to compete, and you don't want to be at risk of, post-discharge, even injunctive claims after that, what do you do procedurally? I'm not sure I know the answer to it, but I started thinking about it, and I don't know if you're that debtor, do you file an adversary proceeding to get a declaration that the contract's terminated because the rejection is a material breach that should suspend all obligations? I think it will be interesting to see what the next step is in trying to, what can you do to relieve a debtor of that obligation? The fresh start concept does seem to suggest that, you ought to be able to work in your given field, and so I just think that there's going to be some more development on that. It's questions, not answers from me on that one.
Yeah, and you raise the other issue that the court discussed in some detail, which is always useful to remind people what the effect of rejection would be, right? So the court said these aren't executory contracts, and even if they were, the effect of rejection is not you, individual debtor, get out of it, right? And so I think that's right, Beth, that there's a question as to what happens to this guy. Do you have any thoughts, Judge?
I think the judge got it correctly. I mean, Judge Nugent always gets everything correctly, but no. I mean, what he said is, you reject the contract. It's not a termination of the contract. The rejection protects the estate from post-petition liability. The rejection frees the state from the obligations. But the protection to the debtor is not from rejection. The protection to the debtor is whether or not those obligations under the contract are discharged. Right. So if it's not a claim and it's not discharged, then the debtor is still saddled by the non-claim obligations under the contract. And I think that's correct. I mean, I think you're right. I certainly agree with Beth that there's a host of facts that we could talk about post-petition, pre-petition. But by and large, the way I look at it is the rejection of the contract protects the estate.
Yes.
What protects the debtor is the discharge. And
Yes.
if your debtor doesn't get discharged, then the debtor's got to be wary of what his or her obligations are going forward.
Yeah, no, good analysis, and I liked the discussion of the effect of rejection of an executory contract in this opinion. Let's turn to a Chapter 13 opinion from the Bankruptcy Court for the District of Vermont. I liked this opinion. I thought this was written very well. This addresses it addresses the automatic stay. It addresses Section 362C3A, which was added to the Bankruptcy Code by the 2005 BAPSIPA amendments, which 13 years later appear to be the gift that keeps on giving. The debtor in Ray Goodrich had filed for Chapter 13 3 months after the court had dismissed his prior Chapter 13 for his failure to comply with the terms of a conditional order of dismissal. According to Bankruptcy Code Section 362C3A, the automatic stay terminates 30 days after a case is filed by an individual if another bankruptcy case of that individual had been pending within the preceding 1-year period. But of course, as with many of BAPSIPA's provisions, the wording is far more complicated than that. Sections 362C3B and C provide the means by which a party in interest can continue the stay upon a showing that the filing of the later case is in good faith as to the creditors to be stayed. In a 2007 opinion, this same court, the Bankruptcy Court for the District of Vermont, had interpreted 362C3A to terminate the stay only as to acts against the debtor or the debtor's property and not estate property, and that the 2007 opinion was called In Re McFeely. A creditor filed a motion in this case, the Goodrich case, asking the court to reconsider its previous interpretation of the statute and declare that the automatic stay in this case was terminated as to everything. The court did reconsider its prior interpretation of the statute, agreeing with courts that interpret 362C3A to terminate the stay in its entirety. So the first part of this opinion contains a thoughtful discussion of reconsideration, which is very useful to everybody litigating in bankruptcy courts. So why is it that the court here found that the moving creditor showed cause for reconsideration?
Judge, I'm interested in your view on this case because, reading that, it seemed to me that the court was maybe taking on a burden that it didn't need to. Because there had been no law from a district court in that division or from the Second Circuit. Mm-hmm. So I think the analysis, sort of the heavy burden of overturning a prior precedential decision, I think maybe wasn't quite necessary, but maybe it's helpful for the court to have pointed out all of the serious consideration it gave and the recognition that on a novel issue like this where there is no clear answer, effectively the sole bankruptcy court opinion in that district is going to govern what happens in that district, just as a practical matter. So, I'm interested in your thoughts.
Well, you raise a really interesting question, and that is, does stare decisis apply to a bankruptcy court's prior decisions? Now, for example, it wouldn't apply in my court where there's 7 bankruptcy judges. And in fact, there's good case law that I'm not even bound technically by district court's opinions because there's so many district court judges in my district, and they're not bound by each other. So I'm not bound. But of course, that's a technical issue. But the judge in Vermont is a sole bankruptcy. That's the only bankruptcy judge. So that court has spoken. So whether it's stare decisis or not, I think that the emphasis that she placed on the importance of consistency and the importance of clarity and the importance of having the bar know that this is the way we're going to treat these issues, and these issues of 362C3 come up, 3 times a week.
Wow.
I think that she took exactly the right approach. Let the bar know that I'm really being careful about this and cautious about this, and that if I'm going to change this, it's going to be with substantial cause.
So there are 3 interpretations of 363C3A, and the court, after talking about cause for reconsideration and the discussion of reconsideration, the court talked about the guidance provided by the Supreme Court in interpreting other BAPSIPA provisions. We've had, since 2005, several Supreme Court cases on some other provisions, obviously not this one. So does the approach that the court adopted here most closely follow the guidance that the Supreme Court has given in these other cases?
I think so. I mean, I have to start by saying Section 362C3 is such a horribly written statutory provision. We've all
Like no other provision in BAPSIPA.
It's the champion. I think it's the champion. I mean, we've wrestled with this for 12 years, and courts have. There's the majority approach that I'm sure we'll talk about, and then there's the minority approach, as you mentioned. But I think that her approach, or let's see what the Supreme Court has done with BAPSIPA, makes sense, because ultimately she looks at the majority approach and the minority approach and looks at the language of Section 362C3 and says neither one of those is really pretty satisfying. Neither one of those really, I mean, we could talk about plain meaning because it says the stay is terminated with respect to the debtor. We could focus on those four or five words. Or we could look at the statutory provision as a whole, and we come up with a majority approach, and neither one of those are really satisfying resolution based on the language. So you really should look at something else. And what do you look at? And so she looked at what the Supreme Court has done, and she said, well, what I think you should look at is the text, the context, and the purpose. And those three elements, when you look at those three elements, it steered her pretty clearly into what's called the minority approach. Because again, the majority approach, given that language, to say it's plain meaning, it's unambiguous, and frankly, in my district, we more or less follow the majority approach. But it's always been sort of a head scratcher, given what the language is. The minority approach, she pointed out so many of the reasons why the majority approach leads to sort of deficiencies. So, for example, if you file a bankruptcy case and Section 362C3 applies because you've had one case dismissed in the prior year, you have the entirety of the automatic stay in place. If you go into bankruptcy court and you fail to prove you filed this in good faith, and the judge says you filed this case in bad faith, there's virtually no penalty, because if you filed this to stop the foreclosure, the result is the foreclosure is still stayed, because the only thing that's not stayed now is some action against the debtor or the debtor's property and not property of the estate.
Right.
Another deficiency that she pointed out is when the Section 362C3 says the stay is terminated as to the debtor, you have to read into that the debtor and property of the debtor. Otherwise, it really makes no sense. So you are sort of adding language to the plain meaning of Section 362C3. So when you do all that, she kind of looked at all that and said, text doesn't lead me to a satisfying result, but context and purpose, the purpose of BAPSIPA, that all leads to the notion that really it should be, the stay should be terminated. Stay should be terminated in its entirety.
Yeah, absolutely. That?
No, I thought that was the best part of the opinion, where she's explaining sort of practically what the result is. And there's the portion of the opinion where she says, well, okay, if we go with the majority approach, so in the case of a bad faith filing, so a creditor gets to make phone calls but doesn't get to do anything else. What does that achieve? I thought that was, I think, the best part of the opinion is sort of the practical. What does this really mean in a bankruptcy case? And I think, I think the portion, maybe this is getting ahead of ourselves a little bit, but the action taken language, I thought was an interesting concept that I, just reading this statute cold without knowing of that case that's out there, I would never have read this section to require this to relate only to an action that was commenced pre-petition, because it refers here to subsection A, which of course prohibits the commencement or continuation of an action, and among a bunch of other things. So, yeah, I think that this was a very carefully reasoned decision, and I think it does do a great job at, matching up practical purposes and achieving the goals that were intended by BAPSIPA.
It certainly, I think, presents the minority approach position as well as it can be presented, and it's very sound in that regard. And whether courts will start changing their views or not, remains to be seen. But I think that I could understand how she reached the conclusion she did, and it was a very good opinion.
Yeah, I did. I thought Judge Brown really laid everything out very well. So anything else to add on the opinion? You were worried about getting ahead of us,
Oh,
but
no.
there's...
I was just going to say, on my little list of grammatical do's and don'ts is going on there. Don't use with respect to 4 times in one sentence. That's going on the list.
Four times in a 44-word
Right,
phrase.
right.
in the statute.
Yeah.
No, there's...
Yeah, I think Judge Small, she quoted Judge Small saying it's a puzzler, and I think that's that euphemistically is the nicest thing you could say about that language. So,
Yes.
yeah, puzzler.
Whoever wrote it didn't read up on statutory drafting, that's
Right.
for sure.
Right.
Okay, well, thank you. So the next opinion illustrates the boundaries of the Rooker-Feldman doctrine. Isaacs versus DBI ASG Co-Investor Fund is a Chapter 13 opinion from the Sixth Circuit. The debtor, Linda Isaacs, filed for Chapter 13 the day before a scheduled foreclosure sale of her home. She brought an adversary proceeding seeking to invalidate a mortgage lien on her home and to stop the sale of the home pursuant to a Kentucky State Court foreclosure judgment. She sought to avoid the mortgage using the strong-arm power, arguing that the mortgage was never validly recorded because the mortgagee recorded it in violation of the automatic stay in the debtor's earlier Chapter 7. After her initial summary judgment motion was denied, the debtor made another argument. She argued that the Kentucky State Court erred in finding that the mortgage even attached to the real estate in the first place because the mortgage documents themselves required that the mortgage had to be recorded for the lien to attach. The bankruptcy court ruled for the debtor on this theory, and the bankruptcy appellate panel reversed, holding that the bankruptcy court lacked jurisdiction under the Rooker-Feldman doctrine, which keeps appeals from state court decisions out of the lower federal courts. The Sixth Circuit agreed with the BAP on the foreclosure judgment issue, but not on the strong-arm claim issue. And it seems to me that the two different claims provide a good vehicle for discussing the limits of the Rooker-Feldman doctrine. So why would one be barred from Rooker-Feldman and the other not?
Well, the Supreme Court has said that the Rooker-Feldman doctrine is a narrow doctrine that applies when a state court loser goes into federal court and essentially seeks the federal court to sit as an appellate review of that state court judgment. And so the court said, you look to the injury that people are claiming in the federal court to determine whether or not they're really seeking appellate review or whether it's a new claim. In this case, what the state court did was determine that the mortgage was valid, that the lien had attached, and that the matter should go to foreclosure. So to the extent that the debtor sought that claim, asserted that claim in the case, that clearly fell within the Rooker-Feldman doctrine because, as a matter of fact, I think the claim for relief was said to determine that the state law judgment was void and was improper, was incorrect. So clearly that, the court said, that's Rooker-Feldman. But the strong-arm claim was a claim where the debtor said, and what the court said was, look, we could accept everything that the state court decided, that this is a valid lien and it's a valid mortgage, but the debtor's claim, the second claim, is that because it was recorded post-petition in the earlier bankruptcy case, it violated the automatic stay, and therefore the strong-arm powers of the trustee allows you to avoid that. And you could make that determination and address that issue without in any way touching what the state court had decided, because the state court hadn't dealt with perfection, it just dealt with validity.
Right.
And so the Supreme Court, the Circuit Court said, nope, this is the second claim is fine under the Rooker-Feldman doctrine. The first claim, however, absolutely bumps right up into it.
Yeah. Beth?
This To me, this opinion was a head scratcher, but actually, I think it was more the Hamilton case that it was discussing
Okay,
was a head
yes,
scratcher.
Yeah.
I still don't fully understand how, we've got Congress in Title 28 has enacted a jurisdictional statute that allows state courts to determine dischargeability issue, whether a certain debt has been discharged. But in Hamilton, I guess because the discharge is such a central purpose of a bankruptcy case and a bankruptcy court's function, the court says, well, an exception exists if we disagree with what the state court did, and it just seems that is sitting in an appellate capacity is saying you got this wrong and overturning it. So I had a hard time getting my head around Hamilton, but once you presume that Hamilton is just not going to change, it's going to be there for the Sixth Circuit. I think this was a very narrow application of Hamilton because the state court proceeding, although it didn't deal with perfection per se, it did deal with when the lien attaches. Does it attach at proper recording or does it attach only on execution? So perfection was kind of at issue in the state court foreclosure proceeding, I thought. So anyway, this one was a head scratcher. I think it is. I'm speechless because I guess I really don't have. I haven't yet formed a view if I feel like this was really the right result, and I think that stems from just not being quite on board with Hamilton.
So I'd like to talk about Hamilton because I thought
Yes.
Hamilton was fascinating. I didn't know about Hamilton. Hamilton said this, yes, state courts can determine whether a debt has been discharged, which makes sense because often it's a defense to a state court collection action. So it said, yes, the state court can make that determination, but the state court has to do that correctly. And if the state court doesn't do that correctly and the debtor goes to bankruptcy court and says the state court was wrong, it does sound exactly like a Rooker-Feldman issue.
Yes.
But what Hamilton said was when the state court makes a determination that the debt has not been discharged and enters the judgment, that's void under the discharge injunction. So the whole thing gets wiped out. The bankruptcy court now gets to look at it anew. The bankruptcy court is not sitting in appellate review of the state court. That was all voided as a result of the violation of the discharge injunction when the state got it wrong, and we're going to let it go forward. It was a very insightful analysis by the circuit court, I thought, and as a way of getting around, perhaps as a way of getting around Rooker-Feldman, but as you say, Beth, another indication how narrow Rooker-Feldman is.
Right, and I'm trying to put myself in the shoes of a creditor in a state court case who has that asserted as an affirmative defense. Under this line of case law, why would you subject yourself to potentially 2 rounds of litigation? Why would you not then, even if you don't have to undertake that burden as a creditor, you're almost forced to go try to get that determination from the bankruptcy court in the first instance, unless you want to risk having to do it twice.
You're exactly right. Maybe it makes some sense to say, hold on here, let's go to the bankruptcy court, let's find out whether this has been discharged, and then we'll figure out where we are.
Yeah, good point.
Yeah, good point.
Yeah, interesting case, I thought, because it really showed sort of 2 different aspects of a
Yeah.
mortgage, right? Whether
Yeah.
it is enforceable between the 2 parties and then whether it has priority in bankruptcy. So I liked this. Okay. Our last opinion is Kuzman's Miami versus Arthur, and that's from the Bankruptcy Court for the Southern District of Florida. This opinion required the court to interpret the Federal Perishable Agricultural Commodities Act, or PACA. The defendant debtors owned and operated an LLC that purchased and sold wholesale produce. The plaintiff is one of the produce suppliers. Before the debtor filed for Chapter 7, the plaintiff sued the debtor and its LLC, alleging violations under PACA, and the parties settled for about $300,000. This opinion is about the dischargeability of that debt. Section 523A4 of the Bankruptcy Code accepts from discharge debts for fraud or defalcation while acting in a fiduciary capacity. Fiduciary capacity is not defined in the code. PACA creates a trust to protect produce suppliers like the plaintiff, and the question before the court was whether a PACA trust is the type of trust that gives rise to fiduciary capacity under 523A4. The PACA trust consists of agricultural commodities and the proceeds from their sale, and PACA requires dealers, like the debtor in this case, to maintain sufficient trust assets to satisfy the claims of beneficiaries like the plaintiff. The court concluded, nevertheless, that a PACA trust does not satisfy the requirements for finding fiduciary capacity under 523A4, and that the debt was therefore not accepted from discharge. So here the court had to determine whether a PACA trust was a technical trust. So let's talk about how the court did that and concluded that it wasn't.
Another in a long line of cases trying to determine whether statutory trusts fit within the
Yes.
requirements of Section 523A4. Now, we know express trusts do. We know that resulting in constructive trusts don't. So what are statutory trusts, do they or don't they? And this court focused on two elements. The first was that PACA did not require segregation of funds, and that PACA allowed the party to use the money for other purposes other than the trust. And he said those two elements are really the elements that cause this not to be a trust for purposes of 523A4. Recognize that there's different authority on that, but he said if you don't have to segregate and you could spend it freely, then it doesn't meet the requirements for a trust for Section 523A4.
Yeah.
And I thought it was really interesting that it spent so much time discussing those obligations to segregate and to not use funds for other purposes only arise after there's been a showing of dissipation. So it really did it made the courts suggest that it's a lot more like a constructive trust that occurs after some wrongdoing has happened. So that's, yes, a PACA trust can include those elements, but it's only after there's been something that's shown to have been done wrong. And the court, I think, did a good job toward the end of the opinion, sort of explaining how the reason PACA was set up this way is to protect the interests of the growers, but also the dealers, to not subject them to significant liability before they've been shown to have done anything wrong.
Right. Yeah, and I did like the way that the opinion really looked at both the language of PACA and compared it to those different types of trusts that might or might not be technical trusts for purposes of 523A4. So anything else you want to add about this opinion?
Only that I think the judge is right, it's a close call, but I also think that when he said there's really no guidance on what is a technical trust, the more guidance we get on whether these statutory trusts, it happens most often, for example, and the judge referred to this, payments made to a contractor by a homeowner or by a building owner that then have to be paid to a subcontractor. Many states impose a trust relationship on that. And states have a lot of different parameters of whether those are trust, and you have to look at each one, and you have to apply the sort of analysis this judge did. So, those are always interesting issues. They're often tricky because you have to sort of figure out where it stops being a kind of trust that's subject to 523A4 and where it doesn't. But we'll see. So we'll see where it goes.
Yeah, well, thank you. So, Judge Catliota and Beth, that's all the time that we have for today, and I want to thank you for an insightful and lively hour discussing these important cases. And we thank our audience for watching. Remember our archive of episodes at eyeonbankruptcy.com. So a personal note, this is my last chance to serve as a regular host. I have really enjoyed doing this since my first episode a year ago last August. I hope our audience has learned as much as I have learned in the past year. Beginning in October, Professor Charles Tabb from the University of Illinois will be your new host, and we're all looking forward to seeing him in this role. First, mark your calendars for the next episode on September 27th, same time when Bill Rochelle will return with his guests, Judge Kevin Carey from Delaware and Paul Zumbro from Cravath in New York. Until then, this is Juliette Moringelo reminding you to elevate your understanding and keep your eye on bankruptcy.